513-487-8663. Mr. Wa, or they send a WhatsApp message and send a WhatsApp message. You don't be dinking town now or say you're fry, you're fry, not for there. If will be on the account. Yadamasi, Yakako, about from crowd to area no, you better call Yakoko any update from Tata Center catch it, not for there. There will be that also. Miss Aswa come be producers are or maso fideni mo mummy fideni from my yedi jumedi ebra on a yenya beman and a lord and an anakosi why dot. So na Danny any A class airboy ewo at large. Director, Mr. Ramon, updates from Tatapsen. Yamakwaba sobe jumedi so.
PK major also. Abrabia ye bahano customers in tini ye banti. Yeah, you're trying to say pet topic a be mo bia ni beje program so nti wo hanom na say untwi obi ama so a I mean this is the time. Share the link so everybody can join. PK
Now Obi Jana.
Is me new be there?
Obi Jana.
Sintra. So who line?
Okay.
My trim ho akogina ba bi kakra.
Oh, okay.
Me was sound na mu na my trim ho akogina ba bi.
Oh, okay. Yeah, now update what Tatap said.
Was it?
Update what Tatap said.
Say yeah, you man emrenti and once or tap now send this simple. Nti baby a will be tap the here you throughout. Nti we was sound na mu we beach we baby out to me you man kama. Anyways, so and yama me no na PK I want us to share. Now tap wants our customers to participate in the development of the app, right? Nti amount chance to say call receiving countries na o click na akwa say call add country bia office any tap so no you can suggest to us then ya ye ho adwuma na dia ka ho nti obia betimi are participating in that the next thing so ayaye ne say o share o limit na obu almost send this ka escafo no pique mo escafo no usika dos nti are wamu na sa na are uniska
Makasa.
okay so muna nasre na
I was trying to make sure say I heard what you said.
Oh, okay. Nti became more escafo sam. To send it to pay say drum limit na they are worried. Now what tap send is doing is you can anticipate, right? Until you have limits, you can increase the limit into cohort. Now ako can not just say ye bill limits anymore mana what you must send them until see a bill will be a bit me send it. Inti and so yeah at the back one idea back until we and so tap is opening in the wings in your brain in the bank account, and we want you to participate in any action that we're taking. The last thing I want to talk about is about fraud. Mr. Remo Abusianfo should be afraid more suspiciously. Now, I can't say be now I mean, you have PK there, all our ambassadors are around. A class is there. This show is also there. You can come out and verify it before you take any actions, especially when they tell you say you best send you code to be into bobo code in the so a basa don't give the code back. We don't do that. Yeah, your information we only call you to verify you say a wa. But ye may boost our say fanam baby my near check in you card be anything suspicious, please damn that. Don't follow and be a victim. Inti piki kakra me wo ho no say in case bibi wo ho na obebusa na e be ya no so after the show so yes around.
Okay, maybe after the show join Q&A session or people may have some questions for you if you know. Okay. Yeah, that's it. Director, thank you very much for the update from Tatapsen.
You're welcome.
Coffees. All right. At this point, we are going to go right into the program and deliberate on the topic for today. Now, our very own lawyer, Victor ESSIEN, will walk us through the process as we go into the presentation and his Q&A, whereby people ask questions. We open the floor for. So usually what we do is we let him feed us with information. That after that, we open the platform for people to ask questions. So once we're going through that, we will also put his information out there. So make sure you look out for the chat session to pick up his office number so that you can contact him. I'll also plead that if your question is already asked due to the number of people that we have and try to get everybody's question answered, if your question is already asked in a different format, let us give another person the chance for them to ask this as well. Once everything is done, if there's time, we're going to open the line for people to also call in, especially for those who are driving and cannot test, or those who are in a different position that they cannot test but want to speak about it. So, Lawyer Victor ESSIEN, welcome to the show.
Thank you very much, PK. It's always a pleasure to join you and
Same
your
here.
viewers and listeners.
Same here.
Yeah.
So before we start, just tell us a little bit of your about yourself in 30 seconds to a minute, just for the purpose of those who are meeting for the first time. Then after that, walk us through the updates of U.S. immigration.
Okay. I was called to the U.S. bar in 1985, and earlier on, I had been admitted to the bar in Ghana, 1977 to be precise.
Oh wow!
And I have spent a good part of my life teaching law at the University of Jos in Nigeria, University of Ghana, Fordham Law School, and lately at Nyansapo College in Ghana. My practice has been devoted mostly to immigration law, and I'm happy to share some of the updates that have come on the scene within the last 5 months or so, because I think the last time we spoke was about 5 months ago.
Yes.
So I want to share what is new since our last discussion.
Okay, thank you.
Well, I would start off from one of the issues that we discussed during our last meeting. That is citizenship birthright. I'm happy to report that as of today, citizenship birthright is still the law of the land, guaranteed under the 14th Amendment to the United States Constitution. What citizenship birthright means is that any individual who is born in the United States, irrespective of the immigration status of their parent, automatically acquires US citizenship. We do know that as of January 20th, 2025, the current administration decided to put a damper, more particularly, they decided to deny the existence of birthright citizenship. What they did was to say that if you were born in the United States and your parents were not lawfully present in the United States, or if your parents were temporarily present, then unless you have a father who is a US citizen, you do not acquire US citizenship. This was met with a lot of challenge by various organizations and in various states. Ultimately, the US district courts granted the challenge and in many cases also put universal stop to the United States government in the form of the present government from basically going ahead from denying citizenship to US born because of the status of their parents. What has happened is that because of the fact that the district courts decided to put universal challenges to what the Trump government did, they took the matter up with the Supreme Court. And the Supreme Court said that whenever a challenge is made, and in this case, a challenge with regard to the status of birthright citizenship, the injunction that is made cannot be universal. The injunction might only apply to the, or inure to the benefit of the parties to the particular case. And the issue of universal challenges of this kind will not be accepted by the Supreme Court. Ultimately, on July 10th, 2025, other plaintiffs went to court, and this time they managed to get the court to certify them as a class action. And because it was a class action, the court was able to place a universal injunction nationwide. The Trump government has still not appealed this decision. So as of August 18, 2025, birthright citizenship is still the law of the land. It is highly likely that there will be additional challenges to the birthright citizenship, and ultimately it will end up before the Supreme Court. What the Supreme Court will do, given the way it has behaved up until now, it's hard to guess. But if you look at the fact that birthright citizenship has been challenged in the past and has successfully overcome those challenges, historically, case law is on the side of the fact that birthright citizenship will still be the law of the land. Of course, there are a lot of people who have very little faith in the current Supreme Court, and therefore still think that Trump may be able to succeed in overturning this historical constitutional interpretation of the 14th Amendment. What the life of the birthright citizenship within the courts has led the Trump government to do is that they have decided that maybe it's easier to deal with or tamper with those issues that are low-bearing fruits and do not necessarily involve constitutional provisions. So one of the things that they have done recently is that they have changed the way in which the age under the Child Status Protection Act, CESPA or CSPA, is calculated. Now, but what is CSPA? CSPA is a legislative act that came in to offer protection to children who were getting close to the age of 21 and therefore run the risk of aging out and not being considered as children, and consequently being denied an opportunity to adjust their status or obtain immigration benefits based on the fact that they are children. Now, the way it works is that if the petitioner files a petition, be it a family petition or even an asylum petition where a child is considered a derivative beneficiary, the law says that the child will continue to enjoy that status up until the time when they age out, they turn over 21, and therefore will not be considered as children again for purposes of adjustment of status. The way the CSPA system works is that there is a different way of calculating the child's age other than the biological age. And the way they do it is that they look at the time the petition was filed and the time that the petition was eventually granted, and you subtract the number of months or weeks or days from the date that the petition was filed. Therefore, the period that you were waiting for the petition to be approved will be deducted from your biological age. And that if at the time the petition is ripe for adjustment, you are 22 and therefore above 21, they will look at the period that elapsed between the date of filing and the date of approval. And if it's 24 months, as sometimes it is, they will deduct the 24 months or 2 years from the age, your biological age of 22. And therefore, you are qualified as a child for purposes of adjustment of status. Now, the issue here is that you want to determine when the child's priority date will become parent. There are two charts that are available these days. There is a chart known as final action date, which is usually later than the other chart, which is the date of filing. The date of filing is when immigration will allow the child or the child's parent, as the case may be, to be able to file the application for adjustment. Now, when you use the date of filing, it is more favorable to the child in terms of avoiding the child aging out. So what did Trump do, or what did the present government do? They said that now, for purposes of the CSPA, we are going to use the final action date, the one that is more restrictive than the date of filing, which is more favorable to the child at the risk of aging out. This can hardly be challenged. It is discretionary. It's up to the executive to determine how they are going to interpret when the priority date is current or when the visa is available. So this has come to pass as of August 15th without anybody really challenging it. So this is how they are going about the business of creating restrictions and placing obstacles in the way of prospective immigrants. Another change that has just been implemented by the Trump administration is the changes to the non-immigrant visa status. What the government has done is that it has changed the validity period for non-immigrant visas, including B1, B2, H1, H1B, F visas, and all the alphabet soup of visas. And now the validity has been reduced to only 3 months, and significantly for only one entry. What it means is that if you are granted an F1 visa or you are granted a B1, B2 visa, you have to travel here within 3 months. But the duration of status is still dependent on the date that you are given when you arrive at the border. Even though you have 3 months in which to travel here, when you get to the border, the consul, not the consul officer, but the immigration at the airport will decide whether to give you 6 months or 3 months or 1 week, as the case may be. So once your visa expires, first of all, you have to leave. And when you intend to return to the United States, you have to go and get another visa, since your one entry visa has now effectively expired and you don't have any other visa again. The other changes that have come about with regard to the non-immigrant visa status is that now there are no interview waivers. Everybody from a 1-year-old to a 100-year-old will have to go and be interviewed for their visa. There are exceptions. The exceptions are those who are coming under an A1 visa or a G1, G2, G3 visa. Those are diplomatic visas. Those can still enjoy the interview waivers. But all other individuals will not be able to enjoy the visa waivers. However, if you are applying for reapplying for a B1, B2 visa, then provided that your last visa expired less than a year ago, and provided that you were 18 years or older when you first obtained your non-immigrant visa, you might be able to enjoy a visa waiver. Another change that has been proposed by the Trump administration is that they want to initiate a 12-month pilot program requesting business and tourist visa applicants to pay a bond of anything between 5,000 to 15,000 in order to curb visa overstays and essentially tighten the entry requirements. This is only a pilot program, and so far Ghana is not affected. The only two countries that have been affected by this pilot program are Malawi and Zimbabwe. Now, there have been mostly restrictions, but there has been one allowance where they have extended for 3 years instead of the prior 2 years. Lawful permanent residents who file for renewal of their lawful permanent resident cards. Until recently, you were only given a 2-year extension from the date that your LPR or lawful permanent resident card expired. Now, when you file the application for renewal, which is the form I-90, when the receipt comes, you are automatically given 3 years to await the time that the visa will eventually, your green card will eventually be renewed and be received by you. They give with one hand and they take with the other. So having provided this leeway and this opportunity, now there have been other restrictions. And I will start with a restriction with regard to asylum applications. Until recently, if you were filing for political asylum on account of the fact that you were running away from persecution on grounds of having suffered persecution in your home country or your country of last residence based on race, religion, nationality, membership in a particular social group, or political opinion, you did not have to pay anything to file your form I-589. Now, you have been hit with a filing fee of $100. And every year that your case remains with the service awaiting adjudication, you pay an additional $100. When you have stayed as an asylum applicant for a period of 150 days after your application was filed and your case has not been adjudicated, and consequently you are eligible to file for work authorization, originally your first work authorization was free of charge. These days, you now have to pay $550 for your initial work permit, from 0 to 550. And subsequent applications obviously would cost, even more. Not only that, when you are before the immigration court, appeals from the immigration court, which used to be $100, are now $1,000. Not only that, if you were filing for parole in the good old days, it used to be $630. I'm talking about advanced parole. Now it's another $1,000. Basically, the Trump administration is using the immigration facility and applicants as cash cows. And every single procedure now attracts a whole lot of expenses. And that is something that we have to bear in mind. This was made as part of the big blue bill, the big bill that Trump and his allies in Congress were able to pass. And as a result of that, it's an act of Congress, and it is not subject to any judicial revision, so to speak. Another issue that has come up recently, also with regard to asylum cases, is that usually when you file for asylum, you are entitled to a hearing before the immigration court under Section 240 of the Immigration and Nationality Act. What it means is that you are allowed to present evidence. You are allowed to be cross-examined by the service. You are allowed to provide testimony, and no matter how long it takes, you are able to have your day in court. What the immigration has started to do is to get the courts to dismiss your asylum application. And once the asylum application is dismissed, you will be rearrested, and this time you will be charged under Section 235 of the Immigration and Nationality Act as an expedited removal. What expedited removal means is that you do not get the fancy frills of due process, and you may be summarily removed. Now, this is not for every case. The immigration is taking advantage of the changes to the expedited removal laws, which now says that anybody who entered the United States less than 2 years ago, and irrespective of where you were apprehended, you may be subject to expedited removal without the benefit of due process. Of course, if you still insist that you have a well-founded fear of persecution, they will give you a credible fear interview, and inevitably, in these cases, you would probably end up being denied. So that is a serious issue that applies essentially to individuals who entered within the last 2 years. Another change in the law, which is also very troubling, is the fact that the Trump administration has decided to classify denaturalization as one of the 5 enforcement priorities. Denaturalization has always been part of our law, but it was reserved for those who had committed serious crimes, typically where they had committed offenses and in their interview, either for green cards or for citizenship, they did not admit to the fact that they had committed these offenses. So denaturalization is a civil action or civil process, and the statute of limitations may not run out. And if you are caught within the throats of the law, what has changed is that under the Trump administration, denaturalization is being used as a weapon of political vendetta. If they do not like you, then they sink the DOJ, the Department of Justice, after you and review your immigration history to see if they can come up with an issue that they can stand on to revoke your citizenship. Now, obviously, you can always have your day in court to challenge the government that they do not have the right to revoke your citizenship based on the facts they have alleged. So we have to be careful. When you are going for your citizenship interview, make sure that you contact an immigration lawyer review how you got your green card and your life in the United States to make sure that you may not be subject to this kind of revocation. I think this is a good point at which to break off and see if there are any questions from any of the issues that I have raised.
All right. Thank you very much. So we're gonna start off with the first question. So the first question is from Jabari Hemis. Can you ask lawyer if he can help someone whose asylum case has been denied if he can help the person to be granted?
I didn't hear the last part.
So he wanted to know if he can help someone whose asylum case has been denied to be granted.
Well, when your asylum case is denied, you typically have 30 days within which to file an appeal. You file an appeal and it goes to the Board of Immigration Appeals. And the board will review the facts and the law and to see if the judge was wrong in denying your application. If the board doesn't think the court was wrong, they will affirm the decision. That will not be the end of it. You will still have another crack at the law, but this time you will have to file with the United States Court of Appeals. If you are in New York, to the Second Circuit. And again, you will get another crack at it. But at that level, it won't be on grounds of differences in the interpretation of the facts. It must be based on the fact that the Immigration Court and the Board of Immigration Appeals had erred in denying your case on constitutional grounds. So there is no magic that can be used. It's based on the facts and the circumstances, and of course the law as it is at the moment.
Okay. All right, ladies and gentlemen, I will take this opportunity to also remind you that the link to the WhatsApp chat room has been posted. So all you have to do is just click on it and be part of the HRE TV WhatsApp platform where we discuss solely topics that we want to discuss. We want to treat here on the show, as well as future suggestions for any topics, or even if you have any resource person that wants to come on the show. Our biggest appeal that I want to throw out there is that we're also looking for an immigration lawyer for Canada. So if you know of any Canadian immigration lawyer, please join this WhatsApp platform and let us know, and we'll follow up with that. Also, there is another link, which is the Friends of Tatapsen. Click on that one and become part of the Tatapsen family and ask any question or concerns that has to do with Tatapsen. So please take note of that and let's have a good time, discussing the way forward. Lottie says, please, as the visa is 3 months, if the immigration officer gives you 6 months, can you stay for the 6 months before leaving, or you have to leave by the visa 3 months? I know you explained about, I think Lottie wants you to go a little detailed.
Yeah, that's what we mentioned earlier on. The validity of the visa, it's only with regard to how long it takes for you to enter the United States. But once you enter the United States, once you get to the border, the immigration officer will determine how long you can stay. And if the immigration officer says that you can stay for 6 months, you are within your rights to stay for 6 months before returning or alternatively, filing for an extension of your B1, B2 non-immigrant visa.
Okay. So this one is from Fanuel Markin. What happens to a F1 PhD student arriving at JFK if the immigration officer decides to limit the visa to only 2 years instead of at least 4 years to finish the program?
Well, you will have to come in, and then when you are about to end your program and you still have work to do, you can get your visa extended. But you know that typically, even though there are suggestions that this may change, when you are coming as a student, they give you what they call duration of status. Duration of status is that they don't give you a terminal date. For as long as you are still going through your studies, you are okay. There are plans now to put an end date to even these student visas, but it has not yet been implemented. So when you get to the border, the immigration officer will give you D/S or duration of status, typically. But if your visa expires in the event that you are given a fixed date and you still haven't completed, you file, and give reasons why you should be, your student visa should be extended.
Okay. Henrietta says, is it true that current green card holders are being detained when traveling to Ghana? Are there any requirements to be met legally when traveling with a green card? Thank you.
No, there's no reason why anybody traveling to Ghana with a green card, a valid green card, should be detained.
Okay. Calvin Danny says, if you missed your court date for the presentation via email and you are being asked to appear in person, however, you fear deportation, what can be done?
And was there a reason why you missed your hearing date? I guess we can't have an answer to that. But normally, when you miss a court date, the immigration judge will order you removed in absentia. And you have a period of time within which to file for the rescission of that in absentia order. So that's what you do.
Okay.
Now, I don't know how, they will not give you an in absentia order and then they will ask you to show up in person unless there's a missing part that we are not being told.
Okay. iPhone 15 Pro Max says, if the person have an active I-20, the years on the visa doesn't matter. Okay, I think he was responding to the previous question. Okay, the next one is from Akosia's iPhone. If your H-1B visa is expired, but your company has filed for an extension for you and you are already in your 240 days, can you adjust your status to F1?
It's been a typical, if you have all the ingredients, to change your status from H1 to F1, you can do that as long as you have not yet exhausted your duration of stay for the H1B. Now, there are difficulties in changing status from H1 to F1 these days. Normally, you are being asked to go home and apply for that change of status. And that, of course, is not a very good, doesn't usually end up well.
Okay. All right. iPhone says, please, if you have advanced parole, can you go to Ghana and come back safely without any problem at the airport?
See, when they give you an advance parole, the parole document itself says that this document is not a guarantee that you will be allowed to re-enter. All things being equal, if there has not been a change in your circumstances, you should be able to re-enter with your advance parole. But my question is, why do you even risk it? You know, I usually don't recommend that in these times, you know, you travel with advance parole, because once you depart and you re-enter, you lose some of the privileges that attach to you in your original capacity. So yes, you can go and come back technically, but don't be surprised if you are harassed at the border.
Okay. Emmanuel's iPhone says, please, I'm Emmanuel with regard to the priority date for immigrant visa. Should, in case your child is caught up with the age, he or she would not be considered based on the decision of Trump administration? Question mark.
Yeah, if you age out and you were originally an immediate relative, in the sense that your parent is a US citizen and you were under the age of 21, and therefore the visa number was immediately available, you will then move, if you are still unmarried, you will move from the immediate relative category to category F1, for instance, if you're unmarried and above 21. What it means is that it will take you a longer waiting period before you are able to come into the United States. And all of this, in this situation, this has to be somebody who is outside the United States and applying for admission. If you are here and you age out, you are out of luck, you cannot adjust your status, you will have to apply for consular processing with a waiver.
Okay. Heather Phipps says, hi, my name is Heather in Oakland, California, and I'm wondering how difficult it is to get a U.S. tourist visa for my boyfriend who is in Accra, Ghana.
Well, I wish I were a consular officer and could tell you what goes on in their minds. Usually, what happens is that when you go for an interview, they are not interested in whether the person you are coming to visit has the resources to be able to entertain you or anything. What they are interested in is that, are you a risk of overstay? If you are a young man who is not working or is out of work, is out of school, and has a girlfriend in the United States who is a US citizen, you bet you will not get a visitor's visa. They would assume that you intend to come, get married, and file for adjustment in the United States.
Okay. Elson says, how long does it take to file for a husband these days?
Well, if the husband is outside the United States, you file the petition, the I-130 petition, you should give it maybe 9 months to 12 months. But that's the easiest part. The more difficult part is waiting for the consular interview. And there are individuals who have been documentarily qualified, i.e., the petition has been approved. They have started the consular process, submitted all the documents that are needed, tax returns, photographs, copies of birth certificates, and the whole 9 yards. And immigration says, well done. You have given us all the fees and the documents that we need for your case to be adjudicated. But do not sell your house. Don't quit your job. Don't expect that you are coming anytime soon. There are individuals who have waited for 2 years and in some cases even 3 years before their interview is scheduled. So that is the difficulty. And, it used to be said that it was due to the COVID and the closure of US consulates abroad. And so it's a universal problem. There are some countries that have been luckier than others. But the Ghanaian situation is problematic. It's taken at least 2 years, and certainly in some cases more than 3.
Okay. So we're gonna read a couple more messages, and we're gonna go to the WhatsApp chat, the HITV chat room, to also read some questions from there as well. Bright Anyagri says, if at the time of filing a form to acquire a green card, you did not disclose that you have children, but disclose that of your, I don't want to continue that sentence for him. But when filing a form for citizenship, what happens to the children you did not disclose?
Well, that's a serious, error. You have to give a reason why you failed to disclose that you had children at the time that you were applying for a green card. If you are a woman, you cannot say that you didn't know that you had those children. Some men have claimed that they didn't know until later that the mother surprised them with the fact that those are his children. You probably would require a DNA to prove indeed that those are your children, and you must pray that they buy the sub-story that you give. It's never a good idea to fail to disclose such obvious facts about yourself. And if you do that, more likely than not, you are going to run into difficulties.
Okay, let's go ahead and get this question here. So someone has a question. It says, who is the form a green card holder should? I think you try to say, what is the form a green card holder should fill when going to stay a year in Ghana?
It's a re-entry permit. It's the form that you file is the form I-131. It is the same form that is used for advanced parole. It is the same form that is used for a host of other applications. You will complete the sections that requires what they call re-entry permit rather than advanced parole.
Okay.
Mhm.
Kofi asks, And by the way, that question was from Charlotte. Kofi asks, how does the fiancé visa work? What is the timeline for approval?
The fiancé visa, first of all, you must prove that within the last 2 years, you and your fiancé have met. Secondly, you have to prove that neither one of you is currently married to other people. Thirdly, you must prove that there is a genuine relationship. And the way you prove that would be, apart from the visits, mutual visits, apart from the receipts of remittances, apart from pictures that you took when you met, and so on and so forth. Now, it doesn't take too long for the fiancé visa to be approved. It is still subject to consular processing, but it is considered almost like a non-immigrant visa. It is not an immigrant visa. So it may not take as long as the I-130 for your spouse. But I have known some to take a considerable length of time.
Okay. Kelvin Danny says, can asylum seeker whose case has not been determined yet cancel his case and get married to a citizen?
As someone's asylum case, what?
It has not been determined yet, but they want to cancel it and get married to their citizen wife.
Okay. Usually, when people file for asylum, it is because they entered the United States without inspection. So you want to make sure that you entered with a valid visa, even if the visa has expired. If the visa has expired and you are married to a US citizen, you can still adjust your status in the United States. And yes, you can apply to request to withdraw your asylum application. There's nothing wrong with that. But if you did not enter with a valid visa, don't even bother. Don't even try it. You cannot adjust your status here.
Okay. Corey Floyd says, as a U.S. citizen, can you obtain citizenship in Ghana and a third country? If so, then do you have to obtain the Ghanaian citizenship first? So it looks like he wants to get a multiple citizenship and not just dual, but multiple citizenship.
Yeah. Essentially, citizenship depends on the country that you are acquiring it. Now, there are some countries that do not allow dual citizenship and clearly do not allow multiple citizenships. When you are a citizen of that country, you renounce your citizenship to all other countries. Luckily, the United States is not that jealous. You can be a US citizen and be a Ghanaian citizen at the same time, and be a citizen of UK at the same time. But you cannot be a permanent resident of the United States and be a permanent resident of Canada at the same time. You can, however, be a citizen of the United States and a permanent resident of Canada. I hope the point is clear.
Okay. Hillary's iPhone says, what about if you file for a fiancé visa?
What about it?
I think they want to know how long it takes.
Oh, I said it would take about 9 months to 12 months to get the approval, but you still
Okay.
have to wait for the consular processing. And,
Okay.
that it's hard to tell, but, you should give yourself another, 6 months to 9 months
Okay.
for that also.
Heather Phipps says, my boyfriend works at the Lands Commission in Accra, Ghana. So as long as he has that job, will he have a chance of getting a U.S. tourist visa?
Oh yeah, he has a good chance if he's working, and he's better than someone who is out of work and out of school. And of course, you have to, he has to submit a lot of documentation to prove that he intends to return and he doesn't want to come and overstay.
Okay.
At the end of the day, it's very discretionary, and it depends on how you answer their questions, and you have to be forthright, give forthcoming with the answers, and it helps if you have not already been denied a prior application.
Okay.
There are some people who are denied and then wait another year and try again. They keep getting denied and so on and so forth. Yeah.
All right. KA1165 says, can you explain how the fiancé visa works? I think you just did. Um, Tahir says, hi, I am a Canadian trying to find work permit job in the US. How can I proceed?
There are very, very strict rules for employment-based green cards. There are employment-based one, which is reserved for individuals of outstanding merit, professors, researchers, multinational corporation executives of high standing. Then you have the employment-based too, individuals with at least a master's degree, including those who can demonstrate that their entry to the United States is of national interest and therefore are eligible for national interest waiver. Then there's employment-based 3, which requires individuals with at least a bachelor's degree. Now, the thing with the EB3 and most of the EB2 is that you have to demonstrate that there are no US citizens or permanent residents ready, willing, and able to do the job that you are going to do. And you must have an employer who will file the I-140 for you, file the petition on your behalf. And it is the employer who has to demonstrate that they have actively tested the labor market and couldn't find anyone who is as qualified as you, or better still, who can do the job other than you. So there is then the other workers. Those other workers, house help, and those that do not require a lot of qualifications. The last two, the EB3 and EB2, take a long time before they arrive, because they have to go through the Department of Labor to establish their eligibility.
Okay.
After the approval, the employer has to prove that they have the funds to support you financially and that the employment is based on a good faith exercise
Okay.
of hiring.
All right. Kenny says, I've always been curious. Any insight as to why they don't provide a reason why one is denied a visa and instead provide a generic denial letter?
Well, they usually will give you, a section of the law which doesn't make much sense anyway. But sometimes they tell you exactly why it's being denied. So it's a discretionary act on the part of the consular officer. It is not reviewable by a court. It is not reviewable by, the State Department. I mean, the officer can pretty much do whatever they want. And short of saying, I don't like you, so that's why I'm not giving it to you, or I think you will abscond when you come, they can go ahead and pretty much do whatever they want. You always wonder, why do some people get it and others don't get it? And sometimes there's not much difference between the two applications.
Okay. So, Bright, I see your message, but I'll say once we put lawyer's information out, try to contact him because I think that is a little bit of exposing information. So I don't want to, read that out there for. So yeah, just talk to the lawyer and get more, of the answers detailed to you. So this is from Jonathan Elikim. Can one file for adopted case when one becomes a citizen?
Yeah, only a U.S. citizen can apply for their adopted children, and the adoption must take place before the child's 16th birthday.
Okay. Joseph Osei says, can lawyer explain how long it takes to file for a sister in Ghana?
If you file for your sister, you must be prepared to wait for 10 to 12 years. Sibling filing is the lowest on the totem pole.
Okay. Ifa says, please, I want to know if you have lived in US for 30 years and don't have legal status. Is there any law for you? I think that's what he was trying to say.
Yeah. Well, there's something called registry, but it is only for individuals who have been living here since January 1st, 1972. So it still doesn't help somebody who's been here only for 30 years. Your long stay here, if it is not up to, from January 1st, 1972, will not help you.
Okay.
But if you were placed in removal proceedings, you could, if you had other equities, be able to file for what they call cancellation of removal because you've been here for that long.
Okay.
It's a long process and it would take forever to explain it.
Okay. So when you call the office, you'll be able to get more detailed information. E.T. says, my spouse has an interview next week to join me. I just lost my job. Is it going to affect the consular decision of giving her the spouse visa?
No, I don't think so. You have already submitted all the documents that you need to submit. And so you are not likely to be asked to produce another, you've given your tax return, you've probably given your pay stub in the past. So that may not necessarily, unless you yourself go and blot out, or the husband goes to blot out that, hey, my wife just lost her job. I want to go and join her so that I can find a job and help her. but typically it shouldn't be a problem.
Okay. Chris says my niece and her husband attended her green card interview since 12 May 2025 until now. She hasn't received any response from the USCIS. What could be the reasons for this delay?
Usually what happens is that if the case is not closed out, then there could be the fact that they were not convincing enough and that immigration intends to call them back for what they call a Stokes interview. Alternatively, there have been instances where everything went well and the officer said, you will hear from us, and it just gets lost in the shuffle. What you may want to do is May till August, it's long, but not that long. If you don't hear from them in September, you should write to the officer to find out what the status of the application is.
Okay. Before I proceed with the rest of questions, we have about 16 questions. I still have to go on YouTube and Facebook to read some questions. How much more time do you have with us?
What's the time now?
It's 7:25, and I know I usually told you 7:30, but I want to know with all the questions left, how much more time we have.
I can do till 8.
I can't hear you. You're breaking
and
up.
That's the maximum. Will that work?
You were breaking up, Lawyer Victor.
Yeah. I say I can stay till 8.
Okay, thank you. All right, I'm going to proceed very fast too. Simone says, how can one prove that they are not married? And I'm pretty sure the question is for those USCIS.
That they are not married to.
I think the question is for the USCIS.
I'm not sure I understand the question.
He said you have to prove you're not married when you file for the fiancé visa.
Oh, so when you said with the fiancé visa, they have to prove that they are not married. And I think the follow-up question is, how can one prove that they are not married?
Oh, you don't have to prove that you are not married. You just say you are not married.
Okay.
And if they think you are married, they have to prove it.
Okay. So then you apply the acquisitorial law on it. Okay. Chief says, my question is, if a person A came into the US as a student on F1 visa, has since graduated and they have a job, so their F1 visa is expired.
Yeah.
Okay. They have an EAD travel card. Can they travel outside and re-enter the country with ease, especially under this administration?
No, they must have a reason why they have an EAD card. If they got their EAD card because they are in what we call optional practical training,
OPT,
which allows you to work, then you are in status and can travel. Now, on the other hand, if you want to make sure that your OPT is valid and you have the service entry to show it. Service entry is the student and exchange visa card or commission. All right. And that way you can be sure that I need to ask whether the EAD also granted him travel authorization. If the EAD did not grant him travel authorization, as some EADs have, then he will have to request for an advance parole to be able to travel. You cannot just get up and travel with a EAD card unless it's endorsed with travel authorization.
Okay. I'm going to go to Facebook and switch over a little bit. Then we're going to come back to Zoom. Rim De Barber says, how true is it that Dignity Act program? I think he wants to know how true about the Dignity Act program.
Dignity Act program?
Mm-hmm.
What is the Dignity Act program?
I have no idea.
Can he be a little more?
Okay, Rim De Barber, if you can elaborate a little bit for and if there's time, he can go into it. Helena Yeboah says, I want to apply for my sisters, for my sisters. I'm confused, but she wants to apply for her sister's daughter wedding and graduation. Oh, she wants to apply for her sisters and for her daughter wedding and it's something about application with wedding and graduation.
Yeah.
Please forgive me the way it's written if I try to break it down, and I hope I'm reading it right. And she's asking on the follow-up, what do I need for the application? When can I start the application process for July 2026?
You know that these days, when you're applying for a non-immigrant visa, it takes a very long time from the date you fill out the application till the date that you may be eligible for an interview. So the idea is to put it in maybe 9 months to the time. And with both graduation and wedding, you know the dates well in advance, so that if you request an interview for a non-immigrant visitor's visa, it doesn't look suspicious. But at the end of the day, you've got to have proof that these events are going to take place. And even after all of that, you've got to demonstrate that you are not likely to be an overstay when you come.
Okay.
In other words, do you have a reason to go back to Ghana? And that this is only a temporary visit and nothing more than that.
Okay. Ohineba Konobuafo says, good to be here. Stephen Eduyabo says, thank you. Were the non-immigrant status changes ever challenged?
Were the non-immigrant
status changes, was it ever challenged?
You were talking about the reciprocity rules that said that it's only for single entry and valid for 3 months. Is that, if that's what you mean?
I think that's what he's talking about.
Yeah, well, you cannot challenge it. It's, the prerogative of the State Department. And even though they claim that they did that to countries that have similar rules in place, we know for a fact that it is not always true. But at the end of the day, that is a prerogative of the Department of State, and you cannot challenge it anywhere. You can negotiate, as I believe some states are doing, negotiate with the State Department to say that, we will do this, we'll do that, we will bend this, and so on and so forth. But it has no, you don't have what we call standing in a court of law in the United States.
Okay, back to Zoom. Okay, let's go to YouTube before we go to Zoom, because I know someone. All right, let's back to Zoom. Yakubu Maliki says, if an H-1B visa applicant expires, can he apply for an asylum?
Oh, you can always apply for asylum, except that if you're applying for an asylum, you have to demonstrate that you entered less than 12 months before you place your asylum application.
All right.
If you've been here for more than a year, you cannot apply for asylum unless you can demonstrate reasons, exceptional circumstances why you are now putting it in.
All right. Phyllis M says, what is the process of helping with a diplomatic visa as a citizen to gain their green card?
What is the process of
Helping with a diplomatic visa as a citizen to gain their green card.
I don't think I understand this question.
I'm trying to understand the question as if you're a citizen and you're helping someone has a diplomatic visa to get a green card.
Well, you know, if somebody has a diplomatic visa, they can, if the circumstances permit, if they are married to a U.S. citizen, the U.S. citizen can file for them. But before they apply for the adjustment of status, they must renounce their right to immunity. There are two forms that have to be filled out, Form I-508 and Form I-536, which the applicants have to, the former diplomat or diplomat who wants to adjust his status has to complete before the green card will be approved. And at that point, he says that I am no longer eligible for my sovereign immunity claims.
All right. Ivan says, with your advanced parole, can ask your lawyer to give re-entry letter if possible. I don't know if it's a statement or a question.
No, your lawyer has no power to give anybody re-entry letter. It is the service that says, hey, you have satisfied all the requirements to obtain the re-entry, and we issue it to you. And you can, if it's a re-entry permit, you can apply, but you have to apply before you leave the shores of the United States. But you can apply and still say that they should send the re-entry approval to you in Ghana or your home country, as the case may be.
Okay. Hillary's iPhone, if you married a U.S. citizen and you had a green card for 10 years and you have not filed for citizenship as you married for 6 years now, will it affect you if you file down?
No, there's no requirement that you have to file for citizenship, in 5 years, 3 years, 10 years. No,
Okay.
you just,
Samadadzi says, is there any way J1 teacher adjusts status to F1 after the program?
The J1 visa is of two kinds. There's one that says that it is subject to the 2-year foreign residency requirement. There are others that are not subject to the foreign residency requirement. If your J1 visa is subject to the 2-year foreign residency requirement, you cannot change your status to another status without satisfying the 2-year foreign residency requirement. You get married to a U.S. citizen, even though you entered with a visa, because of the type of visa you entered with, you need a waiver before the green card can be granted to you.
All right. A question Pofo says, can you please tell us if you do EB2 NIW cases? If you do, can you share your contact details?
Okay, so we will, I think they can go somewhere to get my details, right?
Yeah, but we're gonna get that before we sign
Yeah,
out
at the
and
end of,
just share it to everyone. Michael Martin
okay.
says, "Hi, my friend. Hey, my name is Michael. In Tennessee, I have a F1 visa and doing my OPT, which expires in November. I am married to a citizen. We are waiting for her name change before applying for my green card. Any advice on what to do since my visa expired in about 2.5 months?"
No, even if your visa expires, you still be eligible to file for your green card.
Okay.
So, just make sure that you gather all the evidence of bona fide marriage, so that when you file and you are required to, you'll be able to submit it without any problems.
All right. Yakubu, we're gonna drop the number very soon, the contact information very soon. Kelvin Dennis says we thank lawyer for making things so simple and good to understand. We are grateful. And Heather Phipps says thank you for your help. Derek says hello lawyer. As you said, if you have a master's degree, which is of national interest, plus I have EAD card now, what's the best way to get my green card?
EAD card is not a big deal. What would help is if you have, with the NIW or National Interest Waiver, you must satisfy certain 3 requirements of that you have published in reputable journals, you have attended conferences. In short, you are a scholar of exceptional ability and recognition.
Okay.
And with that, you will be on your way to obtaining the NIW EB2.
Okay. Corey Floyd says, what is the best way to get in touch with you with the consulate for Ghana in the US? And when is the best time to call? We have tried, but with no success.
I would Google the consulate in New York or Washington,
Okay.
as the case may. Try both, because they can both help you.
All right. Joanna Amokwando says, what is the process of inviting someone for a visit and how long does that take? I think you already explained that for the and my love with 3 heart emojis says, please, any updates on childbirth status if both parents are not citizens? You already talked about that too. Fanuel Markin says, has there been a case history when a green card applicant is granted the petition in 48 hours? Is that unusual?
That would be very unusual. I mean, it has to be some, super emergency. I've never tried it, so I cannot say for a fact, but I wouldn't count on it.
Okay. And guys, like I said, please, the video is already recorded. It's live on HITV, Facebook, and YouTube, as well as Startups in Ghana Facebook. So if you go over the UK, always get the playback, and all the Q&As are there as well. iPhone 12 Pro Max says, please, if you filed for your adult kit since 2017 and have received only the acceptance letter and haven't heard from them, what should you do, please? I filed for them in Ghana.
Watch and pray. It takes a very long time with these cases, and it's getting worse.
All right.
Make sure that you have not missed your deadline. You usually have, if you are doing the consular processing, you usually have 1 year within which to contact them. And there are instances where people will let it slide, and before they know, the case has been revoked. So keep an eye on it, but don't be worried if it takes too long.
Please don't forget to go click on both links, HITV platform link, as well as Friends of Startup Centers link as well. Chris says, how long will it take to approve my children above 21 years visa filed in March this year? You already explained that. Henrietta says, good evening, sir. Thank you for your time. Please, what's the current duration for green card replacement?
Usually, I've found out that if you don't let the green card expire before you file for a replacement, in other words, it's about 3 months to the expiration date, and you file, you'll be surprised. You may get it within a matter of months, 2 months, maybe. But if you let it slide, and there are instances where people come and the green card had expired for 2 years, 3 years, that's when it takes a very long time.
Okay.
But they give you, as I said earlier on, they give you 3 years. Once you file the I-90, they will send you a receipt, and it says that your green card has been extended for 36 months from the date it last expired.
Okay.
It
Three.
allows you to travel, it allows you to work, it's like any other green card.
Okay. 347 says, please, my question is, if you win asylum and apply for green card, will be invited for interview. I'm still not getting that
I have
question.
found, I think I know what he's talking about. Usually when you are granted asylum, you have to file, or you may file for your green card within a year. Asylum cases are also subject to the availability of visa. So whilst a marriage case, you file a marriage green card, within months you will go for an interview. With the asylum, it takes a long time, sometimes even up to a year. The lucky thing is that oftentimes you may not be required to attend an interview. They've wasted your time long enough.
Okay.
So that's the situation with asylum green
Kenny wants
card
to know
applications.
if it's possible to get your green card without a green card interview and EAD card.
Yeah, it used to be, during the Biden time, we were getting a lot of green cards without interviews, but not anymore. These days you should be prepared for your green card interview, except it is the case of child filing for the mother, and even mother filing for the child. Sometimes I've seen instances where there are no uh, interviews. But if it's a marriage case, you bet you have to go for an interview.
Okay.
Obviously, you don't need an interview before you get your work permit. It's only for the green card.
Capricorn J Appear says, can you help someone reapply for their citizenship if they were previously denied on the basis for failing to disclose they have kids on their green card?
The basis of failing to do what?
To disclose their kids when they were going for the green card.
Oh, well, you have to come up with a good reason, a good lawyerly reason why you failed to disclose it, and pray that you didn't go and say something ridiculous when they ask you at your citizenship interview. But that's at best it's a misrepresentation, and it may be waivable, and you have to have enough equities to allow you to waive it.
Okay. Renee has two questions. One, how long will spouse get an interview date in Ghana if documentary qualified in May 2025? Petitioner is a U.S. citizen. And the second part is, are there other applications to use for spouse's visit to the U.S. whilst he awaits CR1 visa interview dates? Wife doesn't have family in the U.S. and she's pregnant.
Well, I think I'll take the first question first. That how long does it take to get an interview when you are documentarily qualified? We have instances where people have been documentarily qualified since 2022, and it's now 2025, and they haven't been called for an interview. So go figure. It's taken an inordinately long time to get interviews in Ghana. So that's the situation. The second question I didn't quite get about. What was the second question?
Are there other applications to use for spouse's visit to the US whilst he awaits CR1 visa interview date? Wife doesn't have
No, you
family in the
see,
US and is pregnant.
yeah, they don't like to give you a visitor's visa when you have already indicated your intention to migrate permanently. So you are really out of luck. There are instances where people have applied for K1 visas. So the K1 visas coterminously with an adjustment application. I have not found it very useful.
Okay. I know we got about 10 more messages left. We'll try to wrap it up by 7:55 so that we can get the contact information and also sign him out. So we'll make these questions quick. iPhone says, as H-1B visa holder in USA, can I work for DoorDash since I work only 3 days in a week?
Can you work for somebody else
DoorDash.
other than... Okay. Now, the thing is that H-1B visas are employer specific. So you cannot take one, and use it to work with somebody else.
All right, I think that is well understood. Osbald the Great says, is it true that you will be denied entry if you travel to Ghana with a Ghanaian passport while you are a U.S. citizen? There's so information gone. I think you've already explained that, and we did talk about that 2 weeks ago when we had the other lawyer too. iPhone says, oh, how can I make extra income as H-1B visa holder? Like he said, it's employer specific, so you can make extra income with your employer if you ask for more hours, and that is even if you can ask for more hours. Capricorn GRPS says, can you help someone? We already asked that. Francis Banner says, if I came to the US on an F1 visa as master's student, after completing my master's, I decided to enroll in the bachelor's program. How would that affect my exit entry to the state since I have now moved to a lower degree?
You have to justify why you need a bachelor's degree after the master's. Is it in some other field of study? You probably did your master's in IT, and you now want to do
business,
a bachelor's in mathematics or something. Yeah, that may be justifiable, but you must find a school that is willing to give you an I-20 and willing to stand by you and think that it's a sensible or viable route to take.
All right. Pius Falco says, please, a follow-up question on the excluded child from your green card application. Will the mother do DNA, or is only the father? It's only the father who will do the DNA as the applicant? Thank you.
Well, yeah, if you are trying to claim affinity with this child, then you have to do it, because the DNA will establish that it is 99.9% that this child is yours. It will not do it for the mother. I mean, if it's the mother, it doesn't mean that it's your child, even if you are married to the mother.
Okay, iPhone says, please, the re-entry letter will take how many months to receive it?
The re-entry
letter.
The re-entry permit, it takes a few months. And as I said, once you do your biometrics before you leave, and that means that you must have filed the application before leaving, you can request that the approval be sent to you in Accra, and they will send it to you.
Okay. Vida's iPhone. I have filed for siblings since 2015 and up to now, no reply. And when I call, no response. Please, what should I do? Like you said, siblings takes forever.
Yeah.
Isaac's iPhone. Please, how can I get Ghana card in the US? Is that possible?
Yeah, I got my Ghana card in the US.
So how can they do
with
that?
With the US, the Ghana consulate in, I think, both New York and Washington, D.C. will help you.
Okay.
Call them.
iPhone 12 Pro is answer, please. How do I know about the deadline? I'm not sure what deadline he's talking about. 001 says, please, I am A2 holder and my visa has expired. Can I get my green card through marriage?
A2, yes.
Okay. Ohima says, where is lawyer located? Lawyer, where are you located?
New York, New York.
New York, New York. Gideon says, please, I got my citizenship today and I have my mom here with a visiting visa. Congratulations, Gideon. Can I file for her to stay without having to leave every 6 months? She has been here for 5 months and she supposed to leave next month. Will filing for her make her to stay and wait until her documentation process?
Yeah, your mom should, you should apply for your mom for a green card. And even if a visa has expired, she will still be able to get it here since she entered with a valid visa. However, you should bear in mind that when the green card is given, it says you are a permanent resident. So you are required to remain here as a permanent resident. And you will not be able to travel home for 9 months and then come here for a month and then go back after a month and maintain your lawful permanent resident status that way. They may allow you to do it for some time, but after a while, they may warn you that if you don't file for an I-131 re-entry permit, the next time you come, they will take your green card from you.
Okay. We're going to read the last two questions. I'm sorry, guys. I think we're going to end up having some questions not being read. Emmanuel says, my wife has been denied an F2 visa during my master's degree studies. Do you advise I try again now that I'm working OPT?
The wife has been denied what?
An F2 visa.
Oh,
yes.
No, I mean, if there must be a reason why the F2 was denied. So is she in, I assume she's in Ghana. Yeah, getting the OPT does not move the her case any higher than before.
Let's say I missed a question, so I'm gonna. So you missed my question. I applied for a visa to Ghana on a family trip. I was issued a K1 visa instead of a B2. Is there any problem with that? And I actually missed that because I don't remember seeing this question.
This person is in the US and he filed what?
Applied for a visa to Ghana on a family trip.
Okay.
And he or she was issued a K1 visa instead of B2. Is there any problem with that?
This is a visa to Ghana?
He said he applied for a visa to Ghana on a family trip. I just thought about it. Because Ghana visa doesn't come from the US. It comes from the Ghana embassy in the US.
Yeah.
Then, I think she's probably in Ghana trying to get a visa, a family trip. I don't know. But if you can come back and just rectify that, maybe we can get that in there for you before we leave. Samadadzi says, please, with the 2 years resident rule, if the visa says the bearer is not the subject to section 212 clause E, however, the DS 2019 is subject, what does it mean?
Well, you have to reconcile the two. Find out from the immigration which one. It's what is in the stamp, the visa stamp. That is what is controlling. Okay. So, I would do it. I would do it. That it's not subject to a 2-year residency requirement.
This person, I've not asked a question from this person, but the rest of Ivory Promas and Ohima, I think we're gonna put a number of the lawyer there. So just call, get a consultation time, and just ask those questions very well. Sebe's question will be the last one. Sebe says, someone filed for naturalization but initially didn't list his kids on the application. His naturalization application got denied and is now in removal process. What can he do? I think you already talked about that.
Yeah, he needs a lawyer. I cannot give an answer. Yeah, like this. Yeah, and there's so many questions.
Beth says she's a U.S. citizen going to Ghana.
U.S. citizen going to Ghana, and
So
the
how do you get
Ghana
K1?
consulate made an error in putting K1 instead of B1, B2. If he has not traveled, he should go to the consulate and get it rectified.
Okay. All right. I want to say thank you all very much. Lawyer, what is your number so that we can put it out for everybody to, so that people can contact you, because we got about 5 or 6 people who still have their questions to be asked. So what is your number?
646
646
742
742
9314.
9314. So the number to the lawyer is 646 742 9314.
And I prefer my email address.
Okay, email address.
It's better to get me by email.
And email is
V as in Victor and my last name ESSIEN 06 at gmail.com.
06?
Yes, 06 at gmail.com.
All right. And I'm gonna post that in the chat, and also please make sure you get the number and contact the lawyer and take care of every business that you need to. At this point, I'm gonna call upon directors to go ahead and sign out with you, and hope to see you back very soon and give us more updates and more in depth of what is happening in terms of immigration law. Director, can you please sign out lawyer Victor ESSIEN for us? Danny or Director A-Class, can you guys please sign lawyer Victor ESSIEN for us? Well, if they're not available at the moment, I would say thank you very much for coming. God bless you. We are always appreciative of your time and the opportunity that you give us anytime we knock on your door. His contact information is in the chat right now. So actually, it's going to the waiting room. Let me go ahead and put that message to everyone. So it's lawyer Victor ESSIEN 646-742-9314, and the email address is vasien06@gmail.com. Lawyer ESSIEN, thank you very much.
You're very welcome. Most welcome. Anytime. Thank you.
Yes, sir. Yes, sir. Thank
Bye-bye.
you. At this point, we're gonna hand over the session to Uncle Jimmy whilst he do the Q&A session for TATAPSEN. This is where every question, any question that you have, get asked. Also, do not forget to also join HRTV chat room, and let's discuss topics that we want to see here on the show, as well as the Friends of TATAPSEN chat room as well. Thank you guys very much, and Uncle Jimmy will take over from here and walk us through the process of Q&A with TATAPSEN. Uncle Jimmy, over to you.